shade. They're not fenced in.
Yeah.
I apologize for the delay. Just trying to catch up here. I've been out of the country for a bit, and anyway, we'll get going here. So we're live. Thank you. Not seeing Senator.
Not just yet.
Everyone else count. Okay. Welcome to the Legislative Committee on Administrative Rules, September 19, 2024. Before we get going here, I'd like to do introductions. I'll start on my left here.
Damian Leonard, Legislative Counsel.
Senator Dave Reeds, representing Rutland Council.
Representative Mark Higley, representing the Orleans Lamoille District.
Carol Odie, representing the farming north end of Burlington.
Seth Baumgartz, representing Arlington, Manchester, Sandgate, and part of Sunderland.
Mark McDonald, Senator from Orange County, or most of Orange County.
Representative Trevor Squirrel, I represent Underhill and Jericho. And on Zoom with us today is Senator
Ginny Lyons, good morning, representing Chittenden Southeast District.
Okay, and I just gotta. Okay, you got him. Okay, great. And Senator Bray is just joining us. Senator Bray, are you there? Not yet. Okay. First item on the agenda are the minutes from September 5, 2024. Any discussion?
Make a motion to accept the minutes.
Okay. All those in favor, please say aye. Aye.
Aye.
Opposed? Okay, thank you. First item on the agenda today is Rule 24 E06, Department of Children and Families, General Assistance of Emergency Housing Assistance, Emergency Rules. This was heard in my absence on September 5, I believe. It actually was up prior to that, but we had to postpone it for a couple of different reasons. In my absence in September 5, Senator McDonald was during the meeting, so I've asked Senator McDonald to chair this part of the meeting in terms of conversation, so it wasn't part of that discussion. I've been trying to come up to speed with the issues and the things that were spoken to before. I'll turn to Senator Bray, but I would ask at some point that Senator Lyons also jump in here. Yours.
So the last time we met, we had an emergency rule to deal with housing for the unhoused. And it was on the heels of a previous emergency rule, which dealt with people that were not housed. It appeared 2 weeks ago that there were additional, it was not the same rule being instituted once again, but that the rule we were looking at 2 weeks ago had additional criteria that had not been in the previous emergency rule. And for that reason, we postponed action to this week to find out whether or not there had been policy changes that in the emergency rule, and it was in fact a different rule with different policy. So we are here today to answer that question. So for the agency,
We'll get Senator Lyons first.
oh, I'm sorry, Senator Lyons, you commented last week on this. Would you share your thoughts with us?
Yes, thank you, Mr. Chair. Unavoidably not there today. I do have some suggestions. The number of folks who are being covered was questioned last time, and how that section of the rules relates to what we passed last spring in the budget, in the big bill, the 1100 number. And then there were also questions about resource tests being given to folks utilizing the GA program. So I did reach out and meet and talk with legislative counsel And after we've heard, I think, from AHS, it would be very helpful to have some clarity around at least those two sections of the rules that I mentioned. And then I will probably have a suggestion after we've had our discussion. So just those are my initial comments. And Katie McClin is here, so she
Yeah.
can provide information. I can do that. She's far more fluent in the legal area, and I think be very helpful to explain the differences between what's in the rule and what has been in the program previously for the resource testing. And as far as the underlying legislation goes on the number, I think that is actually pretty clear, and she'll be able to comment on that as well. Thank you. I hope.
So I'm trying to make a decision who we should hear from first, our legislative council or the administration on this issue. And
Well, I would just definitely go to the administration. They were, I think we left with asking them for some further input. So I don't think that hurts. That's up to you.
so we will go to who's representing? I can't read the names on the Heidi for the administration.
Yes, Heidi Moreau.
Forgive me for using your first name. It's the only one I could decipher.
That's fine. Heidi Moreau, Policy Advisor for the Department for Children and Families. We left off at the last meeting with a recommendation by the committee that we meet with stakeholders to discuss the two areas, the requirement to exhaust all available resources and the prioritization policy. So we did meet last Thursday with Legal Aid and End Homelessness Vermont. And what came out of that meeting were two recommendations. The first regarding the requirement to exhaust resources, the recommendation was to have no resource limit. And at this point, the department has decided to maintain the requirement in the emergency rule to exhaust all available resources due to the fact that there are already not enough rooms for eligible households that have no resources, and it wouldn't make sense to further expand eligibility beyond the current resource criteria. The second recommendation was regarding the prioritization policy, and the suggestion was to utilize the reasonable accommodation request under the ADA to create a sort of variance process for the prioritization policy. And while the department is not going to implement a sort of blanket variance process, individuals can always request a reasonable accommodation when a disability interferes with their ability to apply for emergency housing in accordance with the prioritization policy. So that's where we stand after the meeting last Thursday with stakeholders.
Any questions by members of the committee? Representative Higley.
Thank you, Mr. Chair. I don't really have a question, and maybe I'll think different after we hear more testimony, but I certainly can understand the administration's positions around both of those issues.
I have a question, and really the question is going to go to Ledge Council, and whether you'd like to comment on at least what you've heard so far today.
Sure.
Or maybe fill some gaps in that maybe it'd be useful to the committee.
Sure. Some background information maybe.
Yes.
You would like me to jump up here or stay here? Okay.
We'll make it official.
Okay. Good morning, Katie McClin, Office of Legislative Counsel. I was thinking it might be helpful to take a step backwards, actually, because I know this committee probably feels like it is always talking about emergency housing. And I thought maybe it would be important to sort of have the conversation of why there are so many rules that come through on emergency housing. So unlike maybe some of the other programs that you are considering rules for, emergency housing is negotiated as part of the budget, meaning that every year there's sort of a new emergency housing package that is approved by the General Assembly. What that means in practice is that every time there's sort of some fine tuning with what the policy, the emergency housing policy is, that requires a new set of rulemaking to reflect what was adopted in statute or what was adopted in the budget. So that is why you see these rules coming back to you. There were two issues that were brought up when you last met in September. The first issue was the cap, the 1,100 household cap, or room cap, not household. And as you know, there were 4 priority categories that were identified during those periods when it was capped. So there's a cap between September 15th of this year through November 30th, and again in the spring, April 1st through June 30th, through the end of the fiscal year. So those are the 2 periods where there's the 1,100 room cap. As we talked about last week, there is no direction in the budget as to how DCF should achieve that 1,100 room cap during that period. There are no instructions there. So what you're seeing in the rule is the department choosing a course of action to try to reach the 1,100. What I didn't understand from testimony last time, and maybe it was clear to members, was I kept hearing that it was individuals who have a member with disabilities who are going to be the people who are excluded. I've had a lot of opportunities to email back and forth with DCF, and I now understand that there's no prioritization among the priority groups. So among the 4 priority groups, it's sort of a first come, first served basis. But because the number of households with a member with disabilities is so great, it sounds to me like that those are the populations that are more likely to be impacted. And I do have a bunch of information about how the application process works and the timing from DCF. If you'd like to hear more about that, I can read you what they sent me, or you could hear directly from them on that. So that's issue number 1. Issue number 2 was the resource spend down. And I think, again, this took a lot of back and forth with DCF to understand this. So first, we have been using the words income and resource interchangeably. There is not and has never been an income spend down, meaning money that you have earned within the last 30 days. But there has been a resource spend down in GA with regard to certain populations. So in previous iterations of emergency housing, populations were sort of split into 2 categories. Statutorily this year, when the emergency housing was passed by the General Assembly, those 2 separate categories were sort of done away with, and now populations that had been treated separately are all being treated together under emergency housing, treated the same. So what that means, historically, the resource spend down had only applied to households that were in catastrophic situations, and the resource spend down did not apply to the 28-day stays of emergency housing for those households covered under the vulnerable populations category. So you're seeing that one category did have a resource spend down, one didn't. So now there is a certain population of people who are captured under, the current iteration of emergency housing who had never had a spend down, who now do. A member of your committee asked me to ask DCF what the percentage split had been historically between households that were coming in under the catastrophic category and households that were coming in under the vulnerable populations category. The response from DCF is that the historical split has been about 65% coming in from the catastrophic category and 35% coming in under the vulnerable population category. So I hope that provides a little bit of background information to help you make your decision.
Ready, guys? Sorry. Never mind.
Any questions from the committee?
I do. I have a question.
So,
So, yeah, thank you. And Katie, the question is, which aspects of the 1100 and then the resource spend down are in the big bill as it was passed? I mean, so, yeah.
So the big bill spells out 1,100 rooms, so it specifies that only 1,100 rooms are available during those 2 time periods. So that is in the big bill. It does not specify the method by which DCF would get to that number. That is not in the big bill. With regard to the resource test, that there is no mention in the big bill of how to address a resource test. That's maybe one of the hazards of having the program, new iterations of the program every year, because there may be sort of an understanding or thought that policy decisions that are put in place in a rule might carry forward to future iterations and continue to be in place. And therefore, the legislature doesn't have to speak on those particular issues. But, you know, it was not addressed in the legislation.
We are using a lot of terms here today that the general public listening in have their own opinions of. We're talking about households. That could be 1 person, 2 person, 6 people. Is that correct?
I would defer that question to DCF, how they define a household.
Okay.
That's correct. Act 113 defined a household as an economic unit of individuals living together and individuals that are legally responsible for each other. So the department adopted that definition that's in Act 113.
We have had the term housing, which has often been referred to this morning as a room, as opposed to perhaps I don't know, it's referred to as a room, and that room could be in a motel, in an apartment complex, in a gymnasium with a cot. Is that,
So
does it encompass, is that what we are discussing here when we use words that the public would commonly think of differently than how we are using it?
Sure. So the big bill this year articulated that first, if there is a shelter bed available within the district that the household presents itself, then the household would first be placed in that shelter bed, and only if a shelter bed is not available would the household then potentially be placed in a hotel or motel. I'm not aware of potentially apartment complexes being part of the program at this point, but that would be something that DCF could clarify.
That's correct. When we are talking about rooms, we're referring to hotel and motel rooms.
We are looking at rules today that make it legally possible for someone to get a bed in a gymnasium, a hotel room for an individual or a family of an undetermined number of people. Is that correct?
When we say the word rooms, we're not referring to a shelter bed. It's strictly hotel or motel. But Ms. Moreau is correct that the household definition is an individual and any dependents for whom the individual is legally responsible and who live in Vermont. Household includes individuals who reside together as one economic unit, including those who are married, parties to a civil union, or unmarried.
Senator Bray, did you have a question?
Thank you, Senator McDonald. Can you hear me okay?
Yes.
Okay, great. So, we're always conscious in this committee on trying to figure out what's allowed, disallowed based on legislative intent, for instance. So I think I have a question that goes back to Senator Lyons as well as our council and the administration as well. Like, did any legislation passed in the big bill or otherwise this year that's affecting this rule proscribe, make invalid a resource spend down? Did we ever say, no, you can't include that anywhere?
As far as I know, Senator, we did not do that in appropriations where this comes out of the big bill. We also didn't say to use it. So you've got, and you have so you have a split population of catastrophic and vulnerable, some with and some without. And the decision was made to use the resource test.
Okay, thank you. And then
that's by the administration. That was not in the legislation.
Okay, great. That's helpful. And then the other thing is, have we used it historically? In other words, is this like a surprise to us that it's appearing in the rule, or have we used it in the past? And so whether we sort of like it or not, it is, we didn't proscribe it and there's a precedent for it.
So this sort of speaks to, there have been two separate populations and now we're grouping two groups that had been covered under separate rules. Now we're grouping them under one rule. So there is a portion of the households that are being served under emergency housing who did have a resource spend down, and there is a portion who's being grouped under emergency housing this year who historically have not had a resource spend down.
Great. Thank you for that clarification. Okay.
Representative Odie.
So, thank you. So a little while ago, you said, so when legislature puts policy choices that are different in effect, they may, unless they spell out what should happen going forward, they might think it would, now I'm asking the second part, they might think it would just keep going the way it's been going. Because it seems to me, unless they took testimony and said, well, we've decided we're going to do something differently, that they wouldn't, that they would just think it would continue going with the split between catastrophic and glasses on the radio and vulnerable. So why would they think that it would be anything other than that split? I'm just asking you, is it reasonable to say, unless they spelled out that there should be something different going forward, that they might intend that there's no difference going forward?
I think there's sort of an informal reliance over a set number of years that if a particular policy choice hasn't changed and has been sort of consistent, then the legislature sort of informally might begin to rely or understand that this is part of the program.
Okay, so somehow, even though probably that's the case, I would think, unless they broke open a conversation and said, so now let's look at every single detail and let's change what we've been doing, that it would probably, their intention was not to change it from the split. Is that?
I can't answer.
All right, well, then I would like to say that seems reasonable to me, unless they thought that they were going down a different path.
It's,
Representative Higley.
it's kind of on the same question, I guess, and maybe the administration is the one that can answer this as far as when those two groups were combined in the sense of the resource test, there must have been a reason to not continue to have those two groups serve differently. And so I guess I'd just like to ask, you know, Heidi or Nicole, what the thinking was behind that.
I can actually, if Heidi wants to answer, but I can speak to the actual legislative language, which specifically E321C said emergency housing provided pursuant to this section shall replace the catastrophic and non-catastrophic categories adopted by the department and rule. So there was clear direction to get rid of the categories.
Okay.
The question is on the resource test, which applied to one category, but not the other. And for that, I would defer to the department.
Hold on, so we were getting rid of the categories regarding the 1100.
No, so previously, the rule had provided two different categories, catastrophic and non-catastrophic. We said in the statute in subsection C that this shall replace those two categories that had been adopted by the department and rule. The legislature was silent on what to do with the resource test that had applied to catastrophic, but not non-catastrophic. So that's the issue here is this, with that silence, when you're looking at legislative intent, what your question is one, you're the legislature, so and you're the current legislature that enacted this. So you have to think about, was this our intent in enacting it? And if it's something that you didn't consider, the next question is it consistent with the legislative history and the reason and spirit that are behind this act? Is it a reasonable decision within the amount of leeway that we granted the department to implement this program for them to apply this resource test or not? And that is, obviously, that's a difficult and subjective question. And I do want to be clear that there are 180 members in this legislature, and you may not all have the same intent or understanding when you vote for or against something. And so there is some difficulty there. We do have Senator Lyons, who was involved in this, but there is some challenge there with legislative intent anyway, just because every member is an individual, even though you're part of this larger body. But that's where the silence is. So, great.
Mr. Chair, we are now where we were 2 weeks ago. You are up to speed. I'm trying to unload my responsibility here.
Yeah, this is murky, it's problematic. I understand what happens with the initiated program. I had a great conversation with Lex Council a while ago, so I have a better appreciation. But we kind of find ourselves in this situation seems like every year, at least the last 2 years. Okay? So I'm going to turn to our legislative council support and essentially say, as a committee, what are our options?
So you have really three options at this point. The first option is to approve the rule. The second is to object to the rule. And as you all know, the objection is on one of several specific bases. With an emergency rule, is it arbitrary? Is it inconsistent with legislative intent? Does it exceed the authority of the agency? Or is it not? Is there not an emergency? In this case, the question really is legislative intent. And then the third option, which is most frequently used with emergency rules, is to not vote either way on it. So not take a position on the rule, which is what this committee did last year with Rule 23E05, which was the pandemic era general assistance emergency housing transition rule. And in that case, you unanimously voted to neither approve nor object to the rule. And then explain the reasons for your vote to the Secretary of State and the agency. And in that case, there were a variety of concerns with the rule that you elaborated on in a 3-page memo, which you, I believe, approved at one of your subsequent meetings.
Before I offer my comments, Senator Lyons?
Thank you. Damian, thank you very much for that clarification. This is an emergency rule. And first, before I offer my suggestion, I would like to offer some defense of the flexibility and the variability in the GA program on an every year basis. And as we can see, we have different demand each year, and we have different situations each year. So having some flexibility does make sense. On the other hand, it also makes sense to have some clarity. And that's both in legislation and in rules. Because this is an emergency rule, Damian, is it accurate that this rule ends in January?
Yeah, this rule has a set effective period. And I would have to look back at my notes to tell you when it went into effect and when it ends, but I think the department can answer that.
Okay, so, well, but my thinking is to take no action. There's too much murkiness, in particular on the resource test piece that was where we were silent. And to be quite honest, I'm not sure there was a robust discussion about how to deal with that once the two groups were eliminated and put together. That's something we'd have to go back and look at. But I honestly think the best thing for us to do is to allow for the rule to remain as an emergency rule, as it will regardless, and take no action. And in addition to sending the letter to the Secretary of State, we need to send the letter to ourselves, to our appropriations committees, and to our human services and health and welfare committees. This isn't going to go away, obviously. But as I said before, there does need to be some flexibility in how this program or benefit is carried on, because we don't know what it looks like each year. We don't know what how many people are going to be left without the care and the homes that they need. So I'll leave it at that for now, but that is my suggestion.
Thank you, Senator Lyons. And I'm looking at the paperwork here. I think the emergency rule expires on December 28th. Is that correct, Heidi?
Yes, that's correct.
Okay. And the status of the permanent rule?
The proposed rule was filed with the Secretary of State on Friday, the 13th. And the first is scheduled for October 25th.
Okay. I was going to make some comments, but Senator Lyons captured my comments pretty well. So I'm going to go back to Senator Bray here.
Thank you. Yeah, I would support Senator Lyons' recommended path forward, because I don't, there may be consequences of the rule that we don't like, but when we have failed to be explicit enough to prohibit something, I think it seems a little inappropriate for us then to object. So silence seems to be somewhat permissive, and there is, I think, a history of looking to agencies and deference to agency rules when they seem reasonable. So I think maybe the not acting and a letter to express concern about the predicament we're in. I kind of feel like we own this one still. And not acting is a way of raising a concern. So thank you very much.
Thank you, Senator Bray. Any other comments from the committee?
Just a question that in the, thanks, sir. In the current language that deals with both catastrophic and non-catastrophic categories, in the current language, is it assumed to include a resource test in both categories? I just want to make sure I understand.
No,
No.
those two categories have been treated differently with regard to their resource.
Okay, and the current language doesn't change that.
The current language brings the two groups together and applies a resource test.
Okay, that's okay. Thank you. Thanks, Jim.
Any other comments, questions, committee members?
Yeah.
Senator McDonald?
Mr. Chair, the comment was made that we own this. And we're not supposed to be the committee that owns things. But the legislature is supposed to act and make clear policy. And we find ourselves in this position often, too often. We're putting in place a policy that has not been called for by being silent. We're putting forth a policy that has not been called for in statute. If we prove it, we're taking people who do not have homes and are seeking them and stripping them of their assets so that they will not be able to put a deposit on an apartment if they should find one. We are saying to people who have an insurance bill for their automobile to go to work and back, to provide food for the shelter that they might have, be it in one of these shelters, and saying you can't hold on to that money to pay your automobile insurance to go to work and back. And you won't be able to go to work and back legally and have this shelter. I don't want to own either one of those. I don't think the legislature should own that. And I don't think the people of the state of Vermont expect that to be the way we do business. So this is not I have not seen an option here that is satisfactory. Thank you, Mr. Chair.
Thank you, Senator McDonald. Senator Bodie?
Well, I do remember that Nicole Tousignant gave testimony that there is flexibility, discretion. So what I remember asking a question about is, what triggers that someone, having this discretionary decision made, so that I think that it would address some of what the senator has just mentioned. And I don't know whether what you're doing. So I wondered if you might be able to tell us a little bit more.
Heidi, do you want to weigh in on that question?
And I'm actually going to turn it over to Nicole.
Hi, Nicole Tousignant, Economic Benefits Director at Economic Services Division of Department of Children and Families. And I think we had provided some information to Ledge Council, but there is guidance provided to staff regarding when they can offer discretion in terms of resources. So for example, one of the things I know was mentioned last time was if someone has to pay auto insurance, that we ask them to do that and then provide us with the receipts so that we see they spent the resources on that before issuing. So we're able to deduct that. The same thing with car repairs. The staff is able to use their discretion. And if I did not send guidance, I can provide a copy of our housing resource guide, which includes that, which is the resource that staff use when looking at these cases.
Katie?
I did provide, Heidi did provide a snippet from their guidance document. If you'd like, I can read that information. A household must have exhausted all available resources or have resources less than the cost of one night of hotel housing to be eligible for housing. This means the household no longer has enough available resources to secure their own housing. Available resources are defined as liquid resources such as cash, bank accounts, or other financial instruments that can be converted to cash within 24 hours for initial applications. After the first application, households must have taken steps to liquidate any other resources such as cash value of life insurance, sale of stocks, bonds, or mutual funds, cashing of an IRA, or any other reasonably accessible resource. If a household reports that they are saving resources for an emergency expense, such as a car repair, childcare expenses, or medical expenses, please contact GAAOPs to request review of such expenses. In some cases, ESD may exclude resources available to a household from the requirement to exhaust resources. If the household is saving money for a necessary expense, such as car insurance, they should be instructed to pay the bill and provide verification it has been paid.
Senator Bray? Can't hear you.
Yes, sir. There we go. Very briefly, so when I said we own it, sorry to use a vague phrase. I didn't mean Lcar per se. I was thinking of the legislature per se. Overall, by virtue of the fact that we're aware of these kinds of practices and didn't proscribe their application in the housing program, I don't know how we can be aware of a program, not like the consequences of a program, see them manifest in an emergency rule, and then declare that there's a problem with the way that rule was brought forward. So I'm agreeing with Senator McDonald, theoretically, and sentiment. We don't want a program that requires people to be sort of perpetually in poverty. You must spend everything down before you can get help, and you could be stuck there. It doesn't seem like a pathway out. But given our awareness, the legislature's awareness of that when it moved the bill back, the big bill, I don't see the basis for objecting at this point. And that's what I mean by we own it. So thank you.
Senator Lyons?
Just to go back to conversation that was held in appropriations regarding this section of the big bill. There are many of us who had the intent of ensuring that as a temporary housing program in the dates that Katie has identified, that people would find available some place to be and to live. There wasn't a discussion about the permanent buy down of resources in order to find shelter. So in that sense, that discussion, to my recollection, did not happen. So it is a bit of a surprise to see it carry forward in the way it is. I think this is an important conversation. It's a policy conversation that needs to be made. In terms of who owns it, just remember that the negotiation in the budget is between the administration and the legislature. So it's a combination of how we got here. It does ultimately land on our shoulders when we vote, but at some point, as Nicole has said, the guidance document appears to have some flexibility for folks so that they can save enough for a down payment on a house, pay their car insurance and other. That would be best case scenario. But within any area where you have flexibility, you'll have concerns about extremes. So I'll end there, but I still believe that we should allow the rules to go forward without our vote for or against.
Is that a motion, Senator Lyons?
Yeah, it is. Thank you.
Any additional discussion or conversation? I would put that motion to a vote. Should I word that differently? Is that fine, David?
I think that the motion is that Senator Lyons has moved that the committee neither approve nor object to Rule 24 E06.
That's the motion. Any discussion? All those in favor, please say aye.
Aye.
Opposed? Senator Powell. Okay, well, thank you very much, everyone, for this conversation. Difficult conversation, I know, for everyone involved. And I think there's a recommendation that this committee generate, well, we have to generate a report to the Secretary of State. But we'll also generate a memo to the committee's jurisdiction, which are the two appropriations committees, Senate Health and Welfare and House Human Services. And I'll leave it with Ledge Council to get with the various folks and draft that for our review.
Mhm.
There's no vote required at this point until we actually stop.
That's right.
Okay. Okay. We're all good? All right, thank you, Kate, I appreciate it. All right, now we have Rule 24 E07, Office of Professional Regulation, Emergency Administrative Rules for Notary Public and Electronic and Remote Notarization. Is there an Emily?
Yes, my name's Emily Trudeau.
Oh, I'm sorry. I'm looking at the screen and not looking down below, and you're playing with the painting. My apologies.
Camouflage.
You haven't been here on the other ones, have you, on the other emergency rules?
I've not.
Okay. I'm forewarning.
Thank you. I was.
Okay. All right, so I'll let you have the floor and we'll go from there.
Good morning. To introduce myself, in case you don't have the updated agenda, my name is Emily Trudeau, and I'm a staff attorney at the Office of Professional Regulation. An earlier version of the agenda had me listed under a former title I had in a different branch of state government. These are the emergency rules that we filed in late August for remote and electronic notarization for notaries. Since that time, permanent rules have been filed with the Secretary of State in this office, and the public comment period is going to close for those at the end of October. So for the first time, we're able to say, not that we are going to begin permanent rulemaking, but that it is underway. The 8-month clock has started and that those permanent rules have been filed. But we had not promulgated them before the pre-existing emergency rule was set to expire, hence this emergency rule.
And it hasn't changed. It's the same rule, and it's not just the last one. This is like the fourth emergency rule, I believe, fourth or fifth. And 2 emergency rules ago, we had a conversation with Secretary of State's office, whoever was representing Secretary of State, challenging whether it met conditions for emergency rulemaking. And it's not the last emergency rule of this one, but the one before that. And I remember being told, because we asked the question, where we were working on it, it's going to get taken care of. Right? We came back in the iteration before this one, which we asked the same question again and got the same response. And in the last iteration, we actually had a memo from the chair of Lcar saying it doesn't meet standard for emergency rulemaking. You're now back here again. I know you're a step closer to it, but we're not there. And if you could understand my frustration, it's not about that. I don't understand why we're not in a better place with this. And I have a memo from Lcar again in the chair saying this does not meet emergency rulemaking standards. Can you respond to that?
Yes, and understood, Representative Squirrel, and I appreciate the frustration from you and I assume from other members of the committee. This resulted from OPR essentially having one general counsel doing the work of 3 attorneys for a couple of years. I had the pleasure of joining the general counsel unit at OPR last year, along with another attorney who joined with right around the same time. And so for the first time, that unit was fully staffed. At the same time, we were developing and are still developing rules for general contractors, which is an enormous undertaking. And that was something done 2 sessions ago. And in the middle of this, since the last emergency rule was filed in March, our previous general counsel, Lauren Lane, left the office and is now general counsel at the Department of Health. And I don't know if our new general counsel, Jennifer Colin, is not on the phone with us and has picked up the baton ably. But that was a changing of the guard in the middle of this project. I was pleased to be able to pick up the project from where Lauren left off and get the permanent rules filed. But I think it's a simple case of our agency having had too much to do with too few people and having a sincere belief that we'd be able to get them done sooner. But all I can say is that we have them filed now, sir.
My perspective on you, and I appreciate your comments, I do, is that you're not the only agency that has resource issues, or the only department that has resource issues. And we don't get this kind of situation from any other department or any other agency. Just a comment. I appreciate the explanation, but it doesn't feel like an adequate explanation. Committee members? Senator. Can I handle this one? Representative Baumgartz.
Number 6.
One question is that the existing emergency rules expired on the 30th of August.
They did.
It's now September 19th. What has happened during those intervening weeks?
With the emergency rule or with the permanent rule?
What have people been doing? Because the old rule expired, which would have taken us back to whatever the underlying rule said. So what are notaries public doing for those 6 weeks?
So 2 things. One, there is no underlying rule. This is rulemaking for a new rule entirely because this profession is newly a couple of years ago within OPR's jurisdiction. But in emergency rulemaking, as soon as we filed the emergency rule, it took effect. So these rules that are before the committee today have taken effect, but this is the committee's opportunity to object or approve or otherwise act on them.
But I have a follow-up question for Damien, I think is I was reviewing these materials and reading the rationale for Lcar saying it's not an emergency would be, do we actually have the authority, given that it's actually not an emergency, to adopt this as an emergency rule?
So historically,
emergency.
This is not the first emergency rule that has been filed when there is not an imminent peril to public health, safety, or welfare sufficient to justify adoption. So historically, there again are 3 options. One is to approve the rule and just ignore the standard. One is to object because it doesn't meet the standard. And then the third is to vote to neither approve nor object. And that has been I'm obviously new to staffing the committee, but for rules of mine or in my issue area before that have not met that standard, historically, that's been what Lcar has done. And then, expressed what their hopes are. So examples of that would be historically the multi-state lottery system used to update their rules through administrative rulemaking before we changed the statute to allow them to do that with an accelerated process that doesn't go through the APA process. And unfortunately, the multi-state governing body would give them far less time than it took to actually get a rule through the administrative process to update the rules. And if you don't update your rules, you can't sell tickets. So they would file emergency rules every time until we changed the statute to allow them an accelerated process. So in those cases, every time that would come in, Lcar would discuss it and then would vote to neither approve nor object, and would send a memo to the committee's jurisdiction in that case saying, we need to change the statute here. There is legislative authority already to update these rules from 2022, I believe. Please correct me if I'm wrong.
I believe that's the last time the notary statute was amended, yes.
So the authority's there, but you could still vote to neither approve nor object. You could vote to object. When an objection is made under this case, the burden of proof would be on the agency to establish if the rule was challenged, that it was within the authority of the agency. So just like, or the agency could withdraw the rule. My understanding is that the agency, or in this case, the Secretary of State, would not want to withdraw the rule because this is existing practice for notaries public and has been since March 2020, but would rather just proceed with the rule with the objection in place and hope that it's not challenged in the period between now and when the permanent rule takes effect.
So just to make sure I heard you correctly, if we were to vote to neither affirm or object, it's the equivalent in terms of what would happen in the event of a challenge. It's the equivalent of voting no.
So no.
Okay.
That's the difference. If you vote no, they lose the presumption that it's valid. If you vote to neither approve nor object, it
stays. Okay, I just wanted to make sure I was clear.
So that's historically why in these cases, you get into the sticky situation where you have a rule which may be necessary for whatever reason, but it doesn't meet the emergency standard. It's also why frequently in legislation, when they're requiring emergency rulemaking, we say this is deemed to meet the standard, even though we know it's not an imminent peril, because we don't want to have this discussion in Lcar. This is kind of a unique situation because of the clearly in March 2020 and during the COVID pandemic, there was an imminent health, safety, and welfare. Now that the pandemic has passed, that standard can't be satisfied anymore. And so we're stuck with essentially if you're following the standards, either objecting or voting to neither approve nor object.
Yeah, I'll just echo the chair's comments. I am sympathetic to understand that. Wasn't doing a lot of questioning to suggest that this rule doesn't make emergency rule doesn't make sense, because I think it does. And I would just go ahead and say right now that I think probably that neither affirming nor objecting is the course we want to go. But I see another hand up.
Yeah, Senator Bray.
I'm just, if the Secretary's office could provide a timeline for completion of a final rule. Can you tell us where you are on the status of that, please?
Yes, so the rule was filed in July with Lcar and approved by Lcar with recommendations to amend the cover sheets, which we did. And then it was filed with this office along after some stakeholder feedback as well. It was filed with the Secretary of State, I should say, in the middle of last week. And we scheduled public hearings for late October, shortly after the 30-day period is up, and public comment should close at the end of October. And then we can proceed, assuming that substantial revisions aren't needed. I mean, it'll somewhat depend on public comment, how quickly the final proposed rule would be filed.
What was the date it was filed with Lcar?
With Lcar, it was in mid-July.
So it's an 8-month adoption period after that, correct?
It's 8 months from filing with the Secretary of State.
When was that?
So when did you, let me just see.
The permanent rule was the proposed permanent rule was filed with the Secretary of State on September 12th. When did that?
So it's 8 months from there.
Oh, so we're still 8 months out, and there we go.
Yes. We're doing public comment as quickly as we can, so that is going to be held shortly after the 30-day waiting period that's required after publication in newspapers is up. So that'll be in late October. with the last of written comments due at the end of October.
Just a process question. Why the delay between filing at ICAR and filing with Secretary of State?
Well, the ICAR didn't hear, ICAR sits once a month. And so the ICAR meeting was, I believe, the second week in August. And so it was the middle of August that we received the ICAR feedback, although it was filed in July.
Okay. Senator Bray?
I'm feeling betwixt and between, like 844E1D, not necessitated by an imminent peril to public health, safety, or welfare sufficient to justify adoption of an emergency rule. I just don't know how many times this committee wants to, in essence, waive that condition. Sympathetic to staffing, et cetera. I do worry that if we never use that provision, that it becomes somewhat meaningless.
Yeah, to follow up on Senator Bray's comments, there was a situation, I think, about a year and a half ago where we felt that some of the departments were using the emergency rulemaking process to sort of skirt through, and we basically had communication with, I think it was Sean Brown. Is Sean Brown now? He's chair. Anyway, but we had communication with ICAR saying, can't continue to do this. You need to make sure you meet the standard as a committee when you're sending things to us. So to Senator Bray's point. But anyway, Senator Loyan?
I was just going to reinforce what Senator Bray said. I think it's really important that we maintain the standard for emergency rules. The question about what other resources would a department need in order to meet the rulemaking requirements. And I don't know, that's a question for the administration. If more people are needed, well, more workforce is needed within departments or agencies to get the work done, then we should be hearing about that early on in the budgetary process.
Thank you. Senator Weeks?
Yes, sir. I'd like to move that we neither approve nor disapprove 24E07 and send a letter to with the ICAR expressing displeasure for maybe inappropriate use of emergency rules, but at the same time recognize the effort being made in the agency to finalize this issue and allow us to.
We have a motion. Senator Weeks, any additional discussion? Representative Hilton.
Thank you, Mr. Chair. I heard from OPR mentioning the general contractor bill and provisions around that taking a bunch of time. And again, I'd like to go back, and I've mentioned this before, that as a legislative body, we need to certainly understand what we are asking of the certain agencies to do. And a lot of times the agencies seem to be willy-nilly, oh yeah, we got this covered. And I believe there was money in that provision as far as general contractors go for additional personnel or person. And again, I guess as a legislative body, I think it's imperative upon us to have a better understanding of what we ask agencies to do sometime and make sure that they get the needed help that they do. And if that is a detriment to getting things done, then we ought to consider maybe not pushing forward so many bills that require that.
No, I think that's a fair comment, but in this case, it wasn't driven by legislative action, right? It was driven by the COVID crisis and then ended the COVID crisis. So I just wanted to separate those two, but I understand your point about adequately resourcing departments and agencies.
Well, I think it was mentioned that because of the staffing issue and because of the general contractor bill, there was so much work needed around that's part of this problem.
Sure.
But again, yeah, that's kind of unforeseen. But again, I think like I said, I think it's imperative upon us too to understand what we create in government and the expense and time and everything else. Thank you.
Okay, any other comments, questions? Senator Brady?
Yeah, I will be voting no on this motion, because we have plain language in front of us. We've raised this plain language repeatedly, and we haven't seen an adequate response. So to me, it's like we are ignoring the statutory language that guides the committee's response. So it seems at this point inappropriate.
Any other comments? Okay, we have a motion. All those in favor of the motion from Senator Weeks to neither approve or disapprove or object to the rule?
Aye.
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 Against? Senator McDonald? Senator Bray?
I am raising my hand to vote nay. Thank you.
Okay. Thank you.
Thank you.
Would you please convey our concerns to the Secretary of State, please?
Certainly.
Thank you, everyone.
If I may, Mr. Chair,
Yes.
just, I think when we look at something like objecting to a rule, sometimes it seems, I don't know, rather confrontational or negative, something like that. And in this case, to me, it's simply following the plain language of the statute that guides the committee's work. And so it's not, so it's a vote without fear or favor. It's not against any agency. It's that we have a process and it hasn't been followed. And so to me, it merits objection. Thank you.
Senator McDonald.
Mr. Chair, welcome back. You've missed a month of American politics in which we, in this country, have people we disagree with and meet with every day and have discussions like the one we had today that doesn't make us all happy. And when we go home after this meeting, like it happens in other forums, in other states, other legislators, we're ready to come back the next day and welcome each other to the next meeting and muddle through the best we can in our form of government. It's kind of a little microcosm of how we do things in the country we live in. Getting too philosophical here, so I'll stop.
Yeah, I'll have an editorial comment on top of that, Senator McDonald. I just spent 24 days in Great Britain. It was interesting to hear the perspective of folks in that part of the world on our politics here in the United States, and I'll leave it at that. Okay, next rule up. Rule 24, P25, Agency of Human Services, Ambulance Services. Ashley Berliner, you're up.
We can't hear you, Ashley.
Ashley, you're muted.
Good morning. Hopefully this will be easier than the previous two rules you heard. I am Ashley Berliner. I'm the Director of Medicaid Policy for the Agency of Human Services. And I have two rules here for you today, the Ambulance Services Rule, as well as the Beneficiary Protections and Responsibility Rule. I'd like to talk about them first in tandem. We go through the same process. They're part of the same rule filing. And then I will get into the specifics of the ambulance rule, allow you to vote on that before proceeding to the beneficiary rights rule, if that is okay with the committee.
Please proceed.
So for both of these rules, there is no anticipated economic impact. The change in the amendments reflect current practice and coverage for Vermont Medicaid. As a reminder, This is part of a long-standing effort to modernize and update our administrative rules for the Medicaid program under a healthcare administrative rules umbrella that updates the style, makes sure that administrative rule is consistent with current practice, and uses consistent definitions and format. The public engagement for these rules was extensive. It was shared with the Medicaid and Exchange Advisory Committee, Vermont Legal Aid, the Vermont Medical Society, the Vermont Association of Hospitals and Health Systems, Vermont Care Partners, the Visiting Nurses Associations of Vermont, and the Vermont Department of Health and other agencies, Agency of Human Services departments. A virtual hearing was held on August 7th at 12 p.m. and the comment period ended on August 14th. No comments were received publicly on these rules. Since filing the final proposed rule, no changes to either rule have been made. And if it's okay, I'll go now specifically into 4.226, the ambulance services rule. This was last adopted in April 2021, and it has been amended to align our administrative rule with our state plan, which was updated to include treatment without transportation on July 1st, 2023, as a result of activities that occurred during the legislative session. It was amended to include a definition of treatment without transportation and to allow EMTs, AEMTs, and paramedics to provide treatment without transportation and clarify that that treatment may be reimbursed. It also amends the conditions of coverage, which were developed by the Vermont Department of Health and other EMS personnel and were edited to reflect additional feedback following Lcar review. We did not remove anything from the rule, and we do not expect any changes to be controversial after our engagement with stakeholders.
All set? Okay. Committee, questions? On either rule? Senator Lyons?
Which one would you like me to move first?
The
I'd like
first
to-
one, do ambulance services.
Yes, so I'd like to move that we approve Rule 24P25, Agency of Human Services, Ambulance Services Rule.
A motion for Senator Lyons to approve Rule 24P25. Any additional discussion? All those in favor? Please say aye.
Aye.
Okay,
Mr.
opposed? Okay, thank you. Senator Lyons?
Yes, I would like to move approval of 24P26, Department of Vermont Health Access Beneficiary Protections and Responsibilities Rule.
Okay, we have a motion to approve Rule 24P26. Discussion? All those in favor, please say aye.
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 Opposed? Okay, thank you. What?
They were both unanimous.
They were, yes, they were. Just making a note.
Thank you very much.
Thank you, Ashley.
Like that, you're back on track. Thanks.
Okay, next up is Rule 23P44. Reconsideration of rule and corrected changes. Again, this is a rule that was postponed from prior meetings that I was at. And then I think the additional follow-up from that happened in the September 5 meeting. And there was a discussion and a vote taken, but after the fact, Ledge Council with department realized that there was a substantive error or change that needed to be made. It wasn't technical in nature, so they needed to come back to the committee to discuss that one change or correction. So I give the floor to Stuart.
Thank you, Mr. Chair. Again, for the record, Stuart Scher, General Counsel for the Department of Disabilities, Aging and Independent Living. We did not expect to be back before this committee on this rule, but I do want to thank you for the opportunity to return to address that one remaining issue that you identified. As you said, we were preparing to file the adopted rule, which the committee approved at its last meeting on September 5th, at which point the Vermont Healthcare Association reached out and brought to our attention what it believed to be a typographical error in the text of the final proposed rule. But upon review, we agreed that it was an error that we inadvertently failed to correct, but unfortunately, we were advised by Legislative Counsel that this was not a change the department could make unilaterally. Rather, it would require the committee's action on this change. So what exactly is the issue? The current rule provides that a resident may receive services from a home health agency as agreed upon between that provider and the resident for up to 60 days if the home in which the resident is living cannot readily provide those services. The rule also currently provides that if those home health services are skilled nursing services and they will continue for more than 60 days, the residential care home must get a variance from the licensing agency. So when we prepared our initial proposed rule, we sought to change that time frame in both of those locations of the rule from 60 days down to 30 days. However, in response to a public comment received, the department decided to, in fact, retain the 60-day time frame in the existing rule. Unfortunately, the department only reverted to the 60-day time frame in one of those two places, leaving one of them at the 30 days. The department seeks to make the change so that 5.9E also reads 60 days and is consistent with the language in 5.9E2, which is already 60 days. The department has received confirmation from all of the stakeholders that had appeared before the committee to testify on the rule. That specifically is Vermont Legal Aid, the Senior Citizens Law Project, the Long-Term Care Ombudsman, and the Vermont Healthcare Association, and none objects to making this correction. So again, we would ask the committee to approve the final proposed rule as most recently amended and submitted to the committee on September 12th of 2024, which adds the changes that were made as reflected in our memos dated 6/25, July 22nd, August 29th, and September 12th. Thank you.
Thank you. Committee, question? Representative Bonner, go ahead.
I was going to make the motion, so apologies, ready.
Oh, okay. Senator Bray.
Well, I wanted to confirm that I'm not here just to be a curmudgeonly presence today, so I was going to make the motion on the bill. So I'll go ahead and say it. I move that we approve Rule 23P44, Department of Disabilities, Aging and Independent Living, Residential Care Home and Assisted Living Residents Licensing Regulations with proposed modifications submitted by the department in the memorandums dated July 22, 2024, August 29, 2024, and September 12, 2024.
Representative Higley.
Should that not be two separate motions?
Yeah, so the first motion would be a motion to reconsider the rule. The previous vote on the rule in light of the additional change. The second would be to move it. So, but you could table the second motion pending someone making the first motion. There.
You're making the first motion.
I mean,
did everyone hear what Ledge Council just said? We need to have a motion to consider this change to the rule.
I'll make a motion to reconsider.
Okay, Representative Bongartz makes that motion.
So you need to vote on that and then you can vote on Saturday.
We'll do that first, right? Okay. Any discussion on that? All those in favor, please say aye.
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 Opposed? Okay. And then we have the motion from Senator Bray. Any discussion, additional discussion?
Can you rephrase Can you rephrase what this second motion is, just for clarity?
So that this is to approve the rule with the proposed modifications that were submitted in the 2 prior memorandums that you approved at your last meeting and the additional single change that was submitted on the 12th.
Okay, thank you.
And might I also add, it also includes the changes that were included in the original submission of the final proposed rule on June 25th.
Any more discussion? All those in favor, please say aye.
Aye.
Opposed?
Aye.
Okay. Thank you, committee, and thank you, Stuart. Appreciate it.
Thank you so much. Have a great day.
Okay. Just before we adjourn, a couple things. We have 2 letters that need to go, or memos need to go to Secretary of State under 2 emergency rules. And 2 memos going to letters of degrees of jurisdiction on both of those.
Yeah, so do you want separate letters or do you want to copy the committee's jurisdiction on the letter, the Secretary of State?
I'm fine with copying. That's good
Okay.
with me. That will take without objection.
Okay.
There was anything from the meeting, so, right? Okay. Next meeting, Lindsay?
It is October 17th. We have 1 rule officially, and during this meeting, we received 2 others, so we'll have 3 rules for October 17th.
October 17th. Okay.
And deadline is Monday for any others that might be submitted.
All right, so potentially it could be another one that comes in. Okay. So October 17th, right now we have 3 rules. And if for some reason you can't be in attendance, please let Lindsay know. Okay. I think everyone's been pretty good about that. Not hearing anything else. This meeting is adjourned. Thank you very much. Appreciate it.
Thank you.
Thank you. Take care.
Thank you.